Thank you.
This is Tabitha.
All right. Hello. These first two are short. They're Alyssa's fault. They're fantastic. Top notch. Then where we go? Then we move along to some other stuff. Casey Smokey sent me one that's pretty good. I think we're talking about a throuple here. And then somebody, or maybe that's the Karen. I don't know. I've got a Karen on here. It's old. It's from Not So Good Land. Not old, but it's a few days old. She is absolutely insufferable. You're gonna hate it. And then thanks to Zach and Leonard's Unite, yeah, I've got the second part of Buckner's appearance from today. I did the first part in my last stream. So let's get this party started, shall we?
Done. Am I free to leave the Zoom and wait for a response, or would you like me?
No, ma'am. You're not leaving the Zoom. Just mute.
Thank you.
Just mute. All right. Marcelius Ray McNabb.
I'm here.
Mr. McNabb is present. We are going to have a conference. I would ask Mr. McNabb to go ahead and chat his contact information to Taz Taylor, phone number, email address, and myself, or Mr. Taylor will go ahead and give him a call in a moment.
Yeah, Mr. McNabb has 2 cases.
It's 5 cases.
I think that's 5 cases, Your Honor.
5 cases.
And his motion to revoke bond is scheduled on the 15th or the 14th. 15th.
Really? Mr. McNabb, you have a motion to revoke bond that's scheduled, sir. I'm gonna need to see you in court, not on video, for the motion to revoke bond. Are we clear?
Revoke bond for what?
Sir, you got 5 cases. In these 5 cases, you have violated your bond conditions by getting at least 4 of these cases. So, yeah, sir, I'm gonna need to see you in person. Please don't make me send county Uber to get you.
What you want me to do now?
County Uber. I didn't catch that the first time. I love it. You need to come in for an in-person appearance. Bring your toothbrush, because you're probably not going home that day.
Come in person. You're going to be here in front of me on April what?
Your Honor, it's the 15th.
April 15th. You're coming into court for that day, sir. Please don't try me. Please don't make me send somebody to get you. You're going to be present in court. We clear? Courtroom 304-9151 Terra Boulevard, Jonesboro, Georgia, in the great county of Clayton. We clear?
Yeah, so I'm getting locked up.
I'm not sure about that yet. We haven't had a hearing, but I'm going to just tell you, you got 5 cases after you got bond conditions to not do stuff. So we're going to see.
Yes, ma'am.
All right. Thank you, sir. So clear.
Mr. McNabb, please stand by. We're going to contact you in a moment. Go ahead.
I love that sweet. Thank you. Thank you, sir. Thanks for playing. I'll see you soon.
Your mic.
Make it up. Half my doggone 1 o'clock count. Just wild. Don't make a bit of sense. Pearson. Here's another one. Mr. Pearson has 3 cases. Mr. Pearson.
Hello?
I need to see.
Yeah, you said Pearson?
I did say Pearson. You got 3 cases.
I got 3 cases?
Yes, sir, you do.
What?
Mr. Pearson, turn a light on. We're conducting business, sir.
I'm listening.
Sit down somewhere. Oh, I'm sorry. Don't give me the snake face.
Come on, these folks, I got 3 cases.
You have 3 cases. If you sit down somewhere, I'm going to explain to you.
I'm listening to you.
But I don't want to talk to you while you walking. You're going to make me dizzy. I said sit down somewhere. We clear? All right. So, Mr. Pearson, you are before the court on a battery family violence case. You've got 4 charges on that. On another simple battery family violence, you got 2 charges on that. And on a striking a fixed object. That's 3 cases, sir.
When on the family violence case supposed to be dropped?
No,
I don't think they're dropping it. I told you they're not
First
dropping
of
it.
all, hello, Mr. Pearson. First of all, if the person you're talking to is the person who is on these cases, then you're going to violate your bond conditions. You're going to get arrested and you're going to come back and spend time in jail. So whoever
My mama. That's my mama.
well, your mama's not an attorney, so I'm talking to you. You have an attorney.
So I kind of don't want to hear that shit.
It's between me and you.
Pearson,
not-
I don't even have no attorney because the person who filed this told my mama.
Mr. Pearson, you have an attorney. Your case was upstairs in the felony court. You were given a public defender. Because of that, you're eligible for indigent defense here in state court. So you will be appointed the state court indigent defense counsel. So what I want you to do is stop talking, you and your mom.
Wait a minute now, don't tell me. Now let me move, cause you
This
going
is
there.
why you got 3 cases.
Okay,
Ma'am.
you don't tell me to stop talking. I'm grounded.
Mr. Pearson, how old are you? How
I'm
old are you,
30.
sir?
I'm 30. I'm 30.
Okay, so you grown and you need to handle your own business.
I can handle my own business, but I'm asking my
All
mama
right.
for sure. I'm asking my mama for sure.
Well, if she ain't a lawyer, then I don't want to hear from her.
Man. All right, go ahead.
All
Carry
right.
on. Say what you got to say. I ain't got no attitude. Say what you got to say.
I have
Man, he's surprised by that. That comes as a surprise to him. I've always liked her, but I'm liking her more and more. Judge Hayward's fun.
to say, sir. I'm not going back and forth with you. You got 3 cases. We're done.
Not just that.
All right. Next, Aaron Raymond Porter.
Judge, present in the courtroom.
Okay, I haven't seen all of this, but what I have seen is wild. This guy is a vibe.
All right, we'll start this hearing at 9:20 in the morning. We're in Baton Rouge at headquarters. With me is Chuck Tillis on my left, and on my right is Danny Balrod. My name is Steve Prater with the Committee on Parole. We've introduced ourselves, and this is our 3rd hearing this morning. We're talking to you at Bossier Max. Is there any staff in there with Bossier Max, sir? And would you?
Your Honor, we're over here at Bossier Medium now.
I have actually been to Bossier. Okay, I I can't even conceive of what's going on here.
Here for,
PD.
we moved him here for a parole hearing. I'm Lieutenant Roberts, Assistant Warden.
Okay.
I'm Deputy Edwards, Classification Officer here.
Okay. All right. Thank you. And thank you for hosting us this morning. I hope everything's going well up in Bossier.
Yes, sir.
Okay. And we're talking to Nicholas Campbell. Is that correct? Are you Mr. Campbell?
Yes, sir.
Do you know your DOC number by chance?
It's going to be 579383, Mr. Prater.
Okay. And do you have a piece of paper in front of you that's got your name on it that you signed about this hearing, talks about your different rights?
Yes, sir.
And did you sign that and you understood it?
Yes, sir.
Okay. Well, we're going to go over when you get out of jail, because this is a revocation hearing. When you get out of jail and get put on parole, you sign that you agree to this list of things, these list of rules that you're going to abide by. And you're accused by your...
It's a whole list of things. Shit. This is a small town on the border of Louisiana and Texas, and it sounds exactly like you'd expect.
Parole officer violated some of these rules, and you've had a hearing about these. So we're going to go over these rules one by one, and I'm going to let you say if you're guilty, not guilty, or guilty or not guilty with a statement. Okay, we won't talk about this because we want to give you a fair shot. Okay?
Yes, sir.
The first rule that you're accused of is failing to report March through July of 2024. Are you guilty of that or not guilty?
I'm guilty of that. I'm guilty of that, Mr. Prater. But by reason of insanity, almost.
Oh, yes. I saw this much. His defense, I got to set this up for you. His defense is a combination of insanity and a throuple.
See, I'm going to use Miss Fowler's words. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
I'm guilty of that because I had to go and sit in CCC for 14 months, okay? Because I went through the same situation that I'm going through today last year with my other child's mother.
The worst part of this crazy defense, the absolute worst part is I believe him. I believe every bit of it.
I've never been guilty of a domestic crime. What I am guilty of is whoremongering. I've went between these two women and they have used my parole to weaponize it to get back.
Aren't we all, my man? Aren't we all?
Back at me for going between these two women. Okay? Because in 2023, I was in your jail on a domestic charge and it got completely dismissed. Just like this one, it got completely dismissed. Well, when I got out of Tallulah, my anxiety was so high and I had such bad mental health from sitting in that cell 23 hours a day. I was scared to leave the house, Mr. Prater. I got put on Zoloft, a mental medication, and I was so high strung, I couldn't even leave my house to go to get my prescription filled. And then my other baby mama was picking me up and I got caught cheating on the other one. And that's what this whole deal's about. And I just hope y'all see that, today. But I am guilty. I went to that man's office 1 or 2 times and I didn't go after that because of this deal. I was scared to death.
Okay. We'll put down that you pleading guilty to that and we'll try to not chase rabbits so we can get through this list. Okay.
Again, I believe him, but it doesn't take him off the hook legally. But he says it better and with that Southern charm. Okay, we'll put down that you're pleading guilty to that then. That's actually a perfect summation.
One at a time. So you're saying you're guilty?
Yes, sir.
Of failing to report. Okay. Number 3, failed to provide you an address. You didn't give them an address where you would be. Is that correct?
That's not true. I gave them both of my addresses. I got out and I paroled out to Pearson, and I wasn't able to stay there anymore because the man I was living with, my uncle at my shop, he went to the hospital for 9 weeks, and I gave my parole officer my other address in Keithfield.
Okay. All right.
Not true. That one's not true.
Okay, you saying you're not guilty of that? All right.
No, sir. I thought he knew where I was at.
All right. Number 4, you were arrested on a Bossier warrant for domestic abuse strangulation, and you pled guilty to violating a protective order. Is that true or not?
Again, I'm going to plead Throuple. No, okay, I don't know what he says.
Yes, sir. Like I told you, that is true. I plead guilty to a violation of protection order misdemeanor. And I beat the domestic charge just like I told you. I was lied on by a female. I beat it completely. They dismissed it. And what I pled guilty to is I sent $100 cash app to my son's mother for $100 because she had requested me earlier that day. Well, that doesn't work like that. Even though she contacted me first, because I requested the money back from her, she could still, like I told you, she weaponized that and got me on a violation of protection order. And that's what it was $100 cash app for a heart surgery because my heart was broken.
Oh, okay. I got that.
Oh my God. I didn't get that.
That makes perfect sense. Okay, let's move.
$100 cash app because my heart was broken. Holy shit. Can this get any dumber?
Move on to number 6. All right.
Yes, sir.
Number 6, no proof of employment. You didn't have any proof of employment, correct?
No, sir. I gave my parole officer, Brandon Thompson, I showed him my receipt book. I run a mechanic shop out of my garage. And I showed him my receipt book, and he came over and he seen the 2 times he came over, he seen motorcycles on the lift tables, and I had an 18-wheeler torn down in the driveway.
Okay. So you're saying you did have a place of employment, but they just misunderstood or didn't look at the...
I'm self-employed. I own Campbell's Mechanics in Keithfield.
Okay. All right. Number 9, no valid address. You didn't give them a good address.
That was number 2. That's not guilty. I told you, I gave him he knew where I was at both times. I just didn't go see him.
Well, yeah, but no, on number 2, you pled guilty. You first pled at the hearing, you pled not guilty, reason of insanity.
Yes,
then
sir.
you pled guilty today for number 2, and now you're saying not guilty.
Yeah, he had both of my addresses. He had my address in Firestone, and then I told him I was going back to my son's mother's in Keithfield. He had my address.
Okay. All right. And number 10, you pled guilty to owing the Department of Corrections. You hadn't paid your fees for being on parole. Is that correct?
I'm guilty of that, sir. Between 3 kids, my little money was stretched pretty thin. I couldn't pay y'all. I'm guilty of that. I couldn't keep milk in the refrigerator.
Okay. So basically, the most serious one is the number 4, involved in criminal activity. And you're saying, did you ever have any kind of strangulation or any kind of domestic abuse at all to this lady?
No, sir. No, sir. And listen, my wife has sent my parole officer. You can look it up too. She's nuts. She got arrested in your parish for 5 counts of cyber stalking and false communication of a planned arson for threatening to blow up her law firm where she worked at. And then she got arrested in Bossier.
Like I said, it doesn't get him out of the charges, but I do believe everything this man's saying. Like, he's honest. It's not getting him out, but he is not lying. In his country way, he is telling the truth.
For domestic abuse since I've been in jail. But no, sir, my domestic abuse got completely dismissed. I pled guilty to sending that girl a cash app for $100. They knew they had took her word for it, and she lied on me. I'm guilty of going.
They done took her word for it, and she lied on me. I hate it for you. That'll be a nice verse in your country song, but it doesn't get you out of jail.
Between the 2 women, and it causes chaos.
So the only thing you're guilty of is being a whoremonger. Is that what you said?
Yes, sir, being a whoremonger.
Okay, I got you.
Oh my God, this just keeps getting better.
Okay, well that's all the questions that I have.
I'm glad we came to a consensus on the whoremongering between him and the judge at the end. It just brings it all full circle, and I feel better. That's all I'm saying.
Mr. Tillman?
He's explained well. I have no questions.
Okay, thank you, sir. Mr. Barra?
I just have one. You're saying you only pled guilty to that one thing, but on January 13th, 2025, you pled guilty to violating a protective order.
Yes, sir. That was the cash app request. That's what misdemeanor. That's what I pled guilty to. I took 30 days misdemeanor for a violation of protection order for sending her a cash app. And I didn't just send that cash app out of the blue. She sent me a $500 cash app requesting some crazy, and I sent her one back for heart surgery because my heart was broken.
Gotcha. Okay.
There was no harassing, there was no stalking or nothing like that. It was a cash app request.
All right.
And I was
cleared it up.
Yeah. That it? Yeah. Y'all ready to vote?
Yes.
Okay. This was assigned to me, so I get to vote first. And I'm sorry to tell you this, but I'm thinking that you're in violation of all of these rules, number 2, 3, 4, 6, 9, and 10. And so for that reason, your parole is violated, sir. I'm sorry to tell you that as far as my vote goes. Mr. Tillis?
I concur with Mr. Prater. I concur with Mr. Prater.
Okay, sorry to tell you, but the vote is unanimous, and you have been revoked now. And that'll conclude our hearing at Bossier Max. The time is 9:30.
All right, Ms. Brink, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in Brink versus Hildebrand, case number 11-14050. The record should reflect Ms. Brink is present today by Zoom video. Ms. Krause, can you tell me the status of this file today?
This hearing was adjourned from August 5th to allow the plaintiff to obtain.
Okay, I poached this from Not So Good Land. It was put in my Discord. So I need to shout them out. I put a link to the original video in there as well. You're gonna absolutely hate it.
In front of the court forms regarding disability and complete and submit them back before today's hearing. No information has been received regarding her inability to work. The only contact the office has had with the plaintiff is on August 12th when she dropped off a letter requesting to sign off her rights to the child and support to stop. Friend of the court staff did indicate she may need to reach out to probate court to move forward regarding that information. And outside of that, the plaintiff has a support obligation of $197 and a balance of $8,709.16. The last payment was received in February in the amount of $206.47 from a prior income withholding.
Okay, Ms. Brink, why did you not submit those forms as you were ordered to at the last hearing?
I never received them.
Okay.
They were supposed to have been mailed to me.
Did you go in to get the forms?
They were supposed to have been mailed to me. That's why I provided my address at the last court hearing.
Okay. Did you do anything to follow up with that at all?
I mean, it's not really my responsibility when someone doesn't do their job.
Well, it's your responsibility to pay your child support payments, and if you don't pay
But that has
those
nothing to do with the disability paperwork.
Okay, I'm not going to argue with you. We went through this. Yeah, you are, and we went through this at the last hearing.
I don't want to argue with you. I'm not arguing. It's straight from the argument clinic. Monty Python. They did it 40 years ago. It's still good.
We confirmed your address. We told you.
So that they could be mailed to me, which they were not.
They were mailed
and I would
to you.
like to sign off my rights to my children. And Devin said that he would not fight it. Bill did not fight it. He came and he signed. And when it came time for Devin to sign, he didn't show up. And I have a text message saying that he doesn't want, or that he wouldn't fight me on signing off my rights to Lila or John.
Wow. That's all I hear. Oh, it's so painful.
So I'm not sure why he didn't sign the paperwork.
So you still are the parent and you still owe the child support.
But I'm requesting the court to terminate my rights to my children. She has a stepmom that can adopt her. I don't want anything to do with her anymore.
Mom of the year, everybody. Mom of the year. Let's have a round of applause.
Well, there's a process for that, and that process hasn't occurred yet, which means that
okay, well, I've asked for that process to be started a year ago. This is the second time I'm bringing it up.
Okay. Well, you have to do more than just ask. It's up to you to
well, that's why I had the document written up and by an attorney, and so that Devin would sign the paperwork, and he said he wouldn't fight me, and then he didn't show up to sign it. So I don't understand what the big problem is.
Okay, so how are we going to deal with you paying your child support till that happens then?
I don't know. I have a paycheck coming from Boyne River, and you can have that. Okay. But other than that, I have $34 to my name. My house is for sale, and I'm living in my car.
When are you getting that paycheck?
I don't know. It should be garnished. I probably won't even get a paycheck. It should be garnished by child support.
Do we have an income withholding, Ms. Krause, for any employers with Ms. Brink?
There is a potential income withholding, but it wasn't reported. So outside of her indicating where she's employed today, that process could take 6 to 8 weeks. So I can't guarantee that monies would be withheld from that paycheck.
Yeah, it should be. I've never had a problem with it not being withheld in the past.
Okay, well, we don't have the information from your employer, right, Ms. Krause? Is that what you're saying?
Yes, you do. Oh, they reported it.
Hold on, Ms. Brink. Ms. Krause?
An income withholding was sent, but until monies are withheld, we wouldn't be able to indicate if that amount would be withheld. But the employer was not reported. It's pending, so I can't guarantee that the employer received anything.
They did.
Okay.
They told me.
Well, we haven't received any money from them, so apparently they haven't.
I haven't gotten the check yet. I haven't even been, I get paid every 2 weeks. And I've already lost the job. They already fired me.
So you're not employed. You're not employed is what you're saying.
How could they fire this delicate flower?
Not currently, no. I lost the job. I got fired. The bartender didn't like me.
Okay. What about the disability? Where are you at with that?
I filled out all the forms that they requested from me and mailed them back in the timeline that they gave me. But I'm living in my car, so I don't have access to my mailbox anymore. So I have to contact disability today after I get off the phone after I get out of court and report my address to be at my parents' house. Now, there's no guarantee that I'm going to get my mail. My parents don't like me. So there's no guarantee that they're going to tell me that the disability paperwork comes. I'm going to have to, I don't know what I'm going to do because I don't have gas to get to their house. And they have me blocked on the telephone.
Your Honor.
Okay. Yeah, go ahead, Ms. Krause.
In regards to her being homeless, she may be able to reach out to the local post office. They may have something for her in regards to obtaining a P.O. box, but she would need to check further into that.
Well, I don't have money to pay for a P.O. box.
They may have some options for you regarding if you're homeless right now. I don't know the details in regards to that, but it is some information that friend of the court has received in regarding post offices when people are homeless.
Okay, I'll look into that.
All right. Well, here's Ms. Krause. Has there been how many findings of contempt has there been in this case on Ms. Brink?
This would be a first finding.
Okay.
I know where there's free lodging.
I'm not in contempt, Your Honor. I have no problem paying it. It's just I can't get a job because I have felonies. No one wants to hire me.
I do.
I've already put out more applications. I'm not in contempt, though. I have no problem paying. It's just that I can't get a job. No one wants to hire me.
You are in contempt, first of all. I find specifically that you are in contempt because you aren't doing any of the things that I ordered you to do the last time. And
yeah, you see the person who determines whether or not you're in contempt is the judge. It's not you. It isn't like a self-grading test. That's not how this works.
You can't just
Your
say,
Honor,
well,
like what?
like fill out the forms for your disability.
They weren't mailed to me. How can I fill out forms that weren't mailed to me?
I'm not going to
I
argue
called
about
and asked. I
Okay,
called and asked.
Now I'm finding you in contempt for continuing to interrupt me during this court hearing and inhibiting the court's ability to conduct this hearing. You're continuing to talk over me. I'm trying to explain to you.
I asked you a question.
You just told me that you're not getting mail at your parents and there's no guarantee that you're going to get your mail. So how do you know that you didn't get this? We sent it to the address that you gave us.
And I was living there up until Friday.
It's not my problem that you aren't getting your mail. All we can do is send.
I am getting my mail.
Obviously, you're
Not
not.
making sense, Your Honor.
All we can do is send it to you at the address that you give us.
And you
then
didn't.
It's up to you. So you haven't followed through with what you were required to do.
Yes, I did. I called the child support office and asked about it, and they said it was too soon for me to be calling.
And you now so that I can say what I need to say for the record here, because you're continuing to talk over me, and I'm not able to conduct this hearing. So the court adjourned the previous hearing in August to give you an opportunity to submit the forms that were required to be submitted. That's your responsibility to make sure that that's done. We had this colloquy the last time about your address. You gave us an address. That's the address we've been using. If you haven't received the mail, that's between you and the post office and you and whatever is going on with the address that you gave us. All we can do is send out forms. If you didn't get them in the mail, then it was your responsibility to contact the friend of the court, go to the friend of the court, make arrangements to get those forms and fill them out, but that's squarely your responsibility. It's your responsibility to pay child support for your child. That's still your child. Your parental rights haven't been terminated. As far as I can tell, you haven't done anything other than say you want that to happen, to make that happen. So you haven't paid child support. You haven't complied with any efforts of the friend of the court to give you options outside of paying child support. So the court finds that you are in contempt because this would be a first finding of contempt. The court finds that you should be sentenced to 45 days in the Otsego County Jail. The court is going to order that you turn yourself in to the Otsego County Jail by 5 p.m. today. That's September 3rd, 2024, to begin serving the 45-day sentence. If you fail to turn yourself in to the Otsego County Jail by 5 p.m. today, then the court will issue a bench warrant for your arrest.
Court does call the case of the people versus Lawrence Buckner.
Joseph McNabb, people, Your Honor.
All right. Mr. Johnson, you're muted. Sir. Go ahead.
May it please the court, Kareem Johnson, defend on behalf of Mr. Buckner.
All right.
What about definition of anticipating the complaint? We're doing an arraignment?
Yes, I'm going to do the arraignment. And
Okay, so this guy came up today, and then he got passed. He had an appearance, and then it got passed. And Zach over at Leonard's Unite got the second part of it for me as well.
just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
Yes, sir.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. Do you understand that? Mr. Buckner, you can sit down while we go through this.
All right, sir. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
I think the medication's wearing off, if you know what I mean.
Sir, forgive me for my emotional upgrade. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are. Miss.
So there's no video.
You may want to mute that.
This is my freedom just snatched me, and I was understanding this son where I came with that picture. Y'all just charged me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said it wrong. Video, but now you tell me your video. That's what I'm not understanding, because the whole basis of my freedom today was the judge Simpson in the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th Judge Washington work. Okay. Potential. I understand the potential. I just, from the time, I apologize ever since it. I'm a little slow right now, so I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge. Ms. Johnson, Ms. Washington, one bond. Yeah. I understand, Judge. I'm sorry. I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case. As to the formal reading, you waive any further formal reading of the claim standing in. All right.
Yeah, he really wasn't like this. He wouldn't shut up the first time he was up.
All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail. I will. Like, I don't want you to tell the judge to adjourn something. And then I need to be heard on it. And I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy vibe. Like, I need help. Okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, Your Honor, say that for 20 seconds, not.
All right. So in that matter, preliminary examination will be in person. It will be set for April 22nd, 2025, 9 a.m. That is before Judge. Well, all right. Right, but I think that will be before Judge Washington. All right. And on that case, his bond would continue. All right. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? PCC. I set it for the 17th. Pardon? Okay, then I'll set it for the 10th. I'll just set it out a week. April 10th, 2025, 9 a.m. on that matter. As to bond and discuss.
The allegation here is that my client allegedly had some outbursts and witness. I had a chance to look at what was available in the equipment that was done. I'm looking at we can see the strongest the argument. Charge with instruction is intimidation. That means that he was trying to prevent this witness from coming to court, testifying, trying to change what this witness has. All of it goes to whether or not that witness would be able to appear in future court. Taking it best, heard of the prosecution. Said, you've been lying on me. Ms. Evans, my client is not saying he said that, but what the prosecution says that you've been lying. She killed you or something to that effect. She shoots you or kills you. Yeah. Notion is for threatening intimidation is that he has to be doing something to fit this witness, saying, don't come to court, trying to stop this witness. I think even if we hold her to this allegation based on her, I don't think the prosecution should be able to take out a case. And his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, from testifying truthfully. That's what this is. Because I do not believe that they will be successful in conviction, I'm asking that the court set for my client a personal cognizance bond. And here's the reasons why a personal cognizance bond. You have the ability to have no contact. It has a home in Ypsilanti. 680 box. It's not having anything to do with money witness lives is separate. He's self-employed, he raises dogs to sustain himself. He suffers from numerous bad living that was already being raised and he's been shot a lot of times. So he's got health problems that arise from that. Finally, he lives with his autistic needs he has to take care of. He also has a brother who can help him make sure that he returns to all future workmates. It's a responsible individual. They should. I think the charge here is a strong charge. I think it's a charge that even taken in light, most favorable to the prosecution, they will be able to prove that you probably caused that.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam is on first Tuesday. At that time, the victim testified and examined. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked her to go to the bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and the assistant prosecuting attorney. Specifically, this defendant said, you're lying, a lying fucking bitch, I'm going to get you. This is right after she testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, under people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history. They frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no coaching order as for residential place of employment. And frankly, Your Honor, is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during the court proceeding immediately after the testimony of the victim is gravely concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and of the state.
So I'm respond, Your Honor.
Yes, sir.
Obviously, very clearly means something different to the prosecution. So he described it as an angry outburst. Doesn't rise showing any intent to keep anyone doing anything except that angry outburst. And when they head and try to charge or witness intimidation, it's not that the person already testified. Said she was lying. Was angry. It was an angry outburst. But we're not going to try this. Here to show the prosecution is that the court takes into consideration the likelihood of conviction. The likelihood of conviction is, as the prosecution says very clearly, I think that's the case at all. And what you have is not angry outburst that's being spun something based on what they saw in context and unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you agree?
That's right. Making a line with things a separate case, and that's exactly what's going on. You can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, and with their discretion to give it aside. Context of whether or not they would likely to get a conviction based on that flimsy information they have there. That's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to them and say, oh, well, got a new case based on that.
So there seems to be a misperception because the victim testified at an exam that somehow this conduct was not what the victim. The victim's testimony would be needed at trial. And to make this statement, not only that he accused her of lying, but that he was going to get her. When this same victim has seen this defendant firearm at her and rack the weapons, clearly the intent here was to intimidate the witness in question. So based upon this defendant's conduct, I believe that $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to post gas or GPS tether, there will go conditions as to placement of employment residence to the victim. But very clearly, this defendant conduct was demonstrated.
I don't know that I have a name for the.
The name of the victim, Your Honor, is Amy Hudson. That's A-M-E-E. The first name. Hudson.
Say again.
A-M-E-E.
Okay.
Last name Hudson. H-U-D-S-O-N.
All right. Anything else, Mr.
No. What it works is it's on a motion, they respond, they make a response, and it's supposed to stop.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm going to order standard conditions, including no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect or through third parties. I will also indicate that there's be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment. or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate. Should it be that type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash assured. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
It's possibly from the judge watching. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. They got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom.
Okay, and sir, this is the time that I got arrested and you sent me back here. The thing that I was trying to work on you was, the community of people that was helping me, sir. And I know everything I'm saying, that you've already made a decision, is that the video inside Judge Washington's courtroom, Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown, Mr. Brown. Yes.
Thank you. No, I don't, but the conditions I know. Okay. All right. Thank you, Mr. Brown, and I appreciate that lesson on how to conduct a court. No, I always appreciate the help. No, well, some places do it that way. I just let people talk. Okay, you know that because you're still doing it. Okay. Have a good evening.
Lauren Brown, he had a rough day. That the entire time when his dopey client's going off, he's looking at him. He's standing there, very dignified, looking at his client, not saying anything, but you know the expression is just, are you about done? Because this isn't, you're not gonna change the ruling. You know, grousing from your wheelchair on the way to the can. It's not gonna happen. Oh, that was fun. Thanks again, Zach. Zach hooked me up with both parts of that today. If you want to see the first part, it's in the last stream, which I can't even remember. I can't even remember what it was. And I'll lay off the Annie clip. I just made it and I liked it today. I miss me some Annie. Don't worry about Annie. Annie's still kicking. She's with my nephew Ross. Shout out to my nephew Ross. Stepping up like a man. All right. Thank y'all for coming out. I appreciate it. I'll see you soon.